What's up, guys? It's the Bad Wolf. Is everybody having a great holiday season out there? I hope so. What is legal standing? You don't know? Fair enough. Let's take a look at it.
Standing is a legal term used in connection with lawsuits and a requirement of Article 3 of the United States Constitution. In simple terms, courts use standing to ask, does this party have a dog in this fight? Standing limits participation in lawsuits and asks whether the persons bringing a lawsuit or defending one has enough cause to stand before the court and advocate, since not anyone can go to court for any reason. To have standing, a party must show an injury in fact to their own legal interests. In other words, has the party itself suffered some sort of actual harm? In constitutional law, this generally refers to one's legally protected rights and freedoms. If the party cannot show harm, the party does not have standing and is not the right party to be appearing before the court. Just because a party has standing does not mean that it will win the case. It just means that it has alleged a sufficient legal interest and injury to participate in the case. Not every injury, or even a prospective injury, is an injury in fact. Injuries in fact must be real and of some kind that the law recognizes. It's usually not enough that an injury might occur, nor is it enough to be a citizen concerned about the case. A party must actually suffer the injury to have standing. But even if one has an actual injury in fact, the injury must be redressable. That is, it must be an injury for which the court is able by law to provide a remedy. Simple standing examples. If A and B enter into a contract, and B breaks the contract, the injury to A is real and an injury in fact. However, even though B did wrong, and A has an injury in fact, C someone who is not a party to the contract nor directly affected by the contract, cannot sue over A's injury. C does not have an injury in fact, and, thus, does not have standing. C fears that D's dog may bite. C does not have standing to go to court and complain that he should be awarded damages because D's dog might bite him. C lacks standing because C has not actually been injured and cannot sue over his fear. If the dog was acting in a menacing way, was not leashed or contained, etc., a court might find standing. In recent years, notable Supreme Court cases involving standing include the following. Flast v. Cohen, 392 U.S. 83, 1968. Taxpayers have standing to challenge an act that exceeds Congress's taxing and spending power. Lujan v. Defenders of Wildlife.
All right. So what does standing in law mean? Have you been injured? Has the party that is suing or being sued, have they been injured? Are they party to it? You might find in a lot of cases out there that though some people have been taken to court, person doing the suing has not actually been injured. You should take a real close look at the party that's suing and ask yourself, can they articulate the damage and a financial means that was taken from them because of this action? Because if not, then they don't have standing. It means they might be bringing a fictitious case to court. they can't prove and articulate how much they've lost. If they didn't lose anything and they weren't damaged, sounds like a fictitious claim to me. Wonder what the penalties are for bringing forth a fictitious claim.